House from all the way across the road, Dean. It's nice to have you here. We've got you for 10 minutes this morning, so I'll hand over to you to start your presentation.
Kia ora e committee. Thanks for the opportunity to address you on this important topic. As you know, I'm a Professor of Law at Te Waka, Victoria University of Wellington, specialising in public and government law. So I come to this discussion from a constitutional perspective, looking especially at the nature of the norms in play and the relative functions of our important state bodies. And in my view, this bill is constitutionally misconceived. The bill is predicated on the principles of the treaty being a thing or a set of norms created by Parliament, and thus, like other things and legal norms, able to be changed or re-legislated at will by Parliament for obedient application by the executive and the courts. And that's the simplified version of Dacian parliamentary sovereignty on which this bill is based, and some others have urged on you. But for me, the particular and special context we're in means I'm not sure that holds true. Here, it's more complicated than that, and I think this bill risks being constitutionally ineffective. For me, rather than being a thing or independent norms created by Parliament, I see references to principles of the treaty more as an interpretive cue. That is, when referring to treaty principles, it's a message from Parliament to the executive and courts, first, that totality the treaty is implicated, and secondly, signalling the expected style of interpretation. And for that matter, a style of interpretation that generally aligns with our long-standing interpretive traditions here in Aotearoa, New Zealand. Things like text in light of purpose and context, generous and practical and ambulatory readings of instruments, mindful of principles like contra preferendum and so forth. And I fleshed that out, that sort of idea of treaty principles as meaning, I fleshed that out more in written submissions in the context that they were first enacted in 1970s and 80s. But to put it another way, to the extent that treaty principles are a set of norms, they're derivative norms. They're intrinsically connected to the original source instruments, intrinsically tied to totality, the treaty, and its essential meaning in law. And in my view, this is where this bill fails. It ignores the fact that in reality, treaty principles are shorthand for the meaning of totality in the treaty itself. Treaty principles embody something that has existing meaning, and thus the treaty principles are descriptive in character. But this bill seeks to sever that intrinsic and derivative connection and seeks to fill that descriptive reference with normative content, recasting totality in terms of what promoters think it should mean as a constitutional document, regardless of the fact what it actually does mean as a matter of historical and constitutional fact. And in doing so, the catalyst for the bill is an erroneous objection to the work of the courts and tribunal, as if they are legislating content of treaty principles when they're grappling with their application, when actually they're simply undertaking the orthodox interpretive function of elaborating meaning as it exists, meaning of totality, the treaty. And very concerningly, this bill seeks to legislate a legal fiction. And others have explained the variance between what totality the treaty means and what's proposed in terms of principles. And that injects mistruths about totality in the treaty into our statute book and is deeply concerning. That doublespeak about totality, the treaty, would bring incoherence and uncertainty and inevitably leave it to the courts to try and mop up the mess. And in my written submission, I sketched some of the possible responses to that, but it's hard to know how that might play out. Importantly, totality, the treaty means what totality the treaty means, like other constitutional instruments, is ultimately a legal question that is ultimately answered by our judicial branch of government in accordance with the rule of law and the separation of powers. put it bluntly, the meaning of Magna Carta isn't worked out by taking a straw poll at the pub on a Friday night. So too with Te Tiriti, the treaty, and the elaboration of its true meaning in law. It's a matter of considered and sophisticated rendering of meaning. And that's not to say that other branches of the public have no role. For example, the legislature might legitimately particularize treaty duties in specific contexts for action by ministers and public servants, sure, but the particularization is subject to the court saying that's under-inclusive or pointing out it does not reflect the proper meaning of Te Tiriti, the treaty in law. And the public, of course, is a key voice in building our constitution too. But this bill isn't the exercise of the people's, the constituent power needed for a new constitutional settlement, especially where what is being disrupted or cast aside is a foundational treaty between two peoples that predates the genesis of Parliament's institutional form, lawmaking authority, and its constitutional legitimacy. For me, this bill confuses legislating, interpreting, and constitution making, and fudges legislative authority and constituent authority. Overall, the bill is constitutionally misconceived, wrong in principle, and in any event, if it was enacted, I think it is unlikely to be effective too. Kia ora.
Thank you, Dean. We'll take some questions now. We're going to go Duncan, Tamitha, Todd, Takata.
Dean, I'll be quick. Interesting, you started with Dicey and parliamentary sovereignty and the suggestion that it might not be a useful framework. I guess my question is this. Do you see Parliament itself and the work we're doing here as constrained by the treaty?
I'd come at that question with two dimensions. The first one is the one that I've front-footed here, which is the question of whether that Parliament is within the authority of the Parliament to amend Te Tiriti directly. It doesn't actually purport to do that on its terms at the moment, but in effect, that's what it's doing. And I think the argument is that it probably can't do that with bare legislative authority there. So it's outside the competence of Parliament to do, or put another way, if it was done, it's unlikely to be given effect to an application. The corollary question is, what then does that mean in terms of other work of business of Parliament and that is contrary to Te Tiriti, and is that invalid, or is Te Tiriti a constraint on parliamentary authority as it relates to ordinary business? And there is credible scholarship making that very point. And the committee would do well to reread Dame Shana Elias's article on sovereignty, where she advances that very point. Professor Ruru makes a very similar point as well. You know, there is an argument about, there's a little bit more, I think, work to be done on what that means and how that works and so forth. In the present context, the first proposition is probably the one that I think is most important.
Thank you. Tamitha, then Todd.
Oh, I'm happy for Todd to go before me.
Just a quick question then.
Education within.
Could Parliament codify the articles of the treaty by legislation?
He decides it there.
Yes.
It's a question of some nuance, because a good faith particularation of the treaty principles, which is still leaves intact the ability and the authority, the constitutional role of the courts to elaborate the meaning of Te Tiriti and to signal to Parliament through declaratory relief or through other means to say that what Parliament has enacted is under-inclusive or is at odds with the treaty. If that was left open, there's a possibility there. But this is not that.
And that's not what I was asking.
Yeah,
I was
yeah,
asking specifically the treaty.
Todd, allow him to finish. Thanks, Dean. Tamitha.
Oh, okay. I'm going to ask you the same question I asked Horiana. This bill is an absurdity. What can we do to stop bills like this coming through? Because clearly this is an enormous waste of time and is just a big spectacle. So how do we get better laws, far better laws than this one?
Yeah, for me, a lot of this, and I'll be quick on this, is improving our constitutional literacy. And it's a big mission, a big project across all dimensions of our of our community, our civic life and so forth. And that's that civic literacy, which understands the constitutional arrangements, doesn't talk in mere slogans of parliamentary sovereignty, as if it's an answer to everything. These questions are nuanced and complicated. In schools, we've got to understand our history and so forth, our universities and so forth. We've got great resources. A lot of this stuff has been traversed in the Waitangi Tribunal and scholarship and court decisions as well. We need to bring that into that conversation. So it's a considered conversation and a sophisticated conversation amongst our polity.
Thanks, Thank you for your time this morning.